Now, I'm pleased to turn the call over to your host today, Darryl Hammann, Executive Vice President, Disability Operations from Sedgwick. Darryl, please go ahead.
Thank you very much. Thanks, everyone, for attending today's call. We know that ADAAA continues to be a hot topic for most employers and in the industry that I'm in. And so today, we're going to spend some time and we're going to hopefully help you understand a few different things. We're going to help you understand what ADA is and what ADA isn't intended to be. I think with the amendments to the ADA, what we've seen is that most employers now have taken a very conservative approach to the ADA, and so I think we've seen some blending of that. Some things now are being characterized as ADA that truly are not ADAAA. So we're going to talk a little bit about that and hopefully clarify that for you. We're also going to talk about how ADAAA interacts with other reasons that employees are off work. So obviously there's folks who are off work for workers' comp, disability, leave, also for just casual absences. I'm sick. I have the flu for a few days, and we're going to talk about how and if it actually interacts with those different leave types. We're also going to talk about how you engage employees to consistently pursue the interactive process. There's going to be some themes that you're going to hear from Shawn and I throughout this process today, and one of those is consistency, and also, the current amendments to the ADA. It's clear that there needs to be an interactive dialogue with the employee to try to determine what the best accommodation is. So we're going to talk through that process with you, and then hopefully give some ideas and thoughts on reducing the administrative burden and documentation. Obviously, it's very important that documentation is consistent, it's thorough, but we also realize that this burden of making sure all that is documented, puts a burden on employers. And so we're going to talk through some things that we've seen in the industry. So let's talk about, let's take a second to go back and just talk about the Americans with Disabilities Act. It was originally went into play in 1990, and at that point in time, it was pretty simple. The intent of the law was to end discrimination against employees who had disabilities, and the law was also intended to make sure that employers really tried to find reasonable accommodations to help disabled employees out. I think we all would agree that those two concepts, most people on this call would agree with. They would think it makes sense. And I think that from 1990, for the next 18 years, much like with any other law, there were lawsuits, there were court cases, some cases got to the Supreme Court. And over that period of time, the original intent of that law eventually started to become narrowed because of some of these decisions. For instance, one of the famous decisions back in the early 2000s was around two pilots who were applying for a job at a major airline. They had 2200 vision, and the employer required 20/20 vision uncorrected in order to fly airplanes as a pilot. The two pilots who were applying for the job sued under the Americans with Disabilities Act, and the Supreme Court case ultimately got to the Supreme Court, and the Supreme Court decided because their vision could be corrected, they weren't really disabled, and so they were not covered under the Americans with Disabilities Act. So they had no recourse to go back to the employer. That case and a number of other cases at about the same time started to get the attention of Congress, and Congress felt like the way that the law had been litigated and decided on was not its intent, and so there came the 2008 amendments, and ultimately, the amendments got back to the original intent of the law, but because employers had been really handling it in a certain way over the previous 18 years, it definitely, the changes created a lot of concern and changes that needed to be done the employer level. And I think what we've seen, and I think you would see this talking to some of other employers, is while the changes in the amendments may have went back to the original intent of the law, it's also created some confusion or some overreaching to include things under the ADA that really it was never intended to do. So, for instance, performance issues. The ADA does not excuse, bad performance. And I think sometimes that gets confused, or otherwise people don't deal with performance issues when there's also a potential accommodation. So, for instance, in my role, if I had an accommodation for, let's say, I could only type 6 hours a day, and I worked with my employer, and they were able to get some various technology, and they were able to accommodate me in my role. They were meeting their requirement under the ADA. But if in my work performance I was not doing the things that I was required, if we were losing clients, if I wasn't managing to my budget, if I had very spotty attendance and I wasn't doing all the other requirements of my job, just because I had a ADA accommodation would not mean that my employer should not also deal with my performance. So it's very important. I understand sometimes those may cloud. There may be the accommodation that's being made may impact their work, but you need to take time to make sure you separate what is a part of the accommodation or the disability and what is just them not doing their job. Second area that the ADA was not intended to do was to force employers to change or change jobs or create jobs for employees. And there was a recent court case, Spears versus Charlie Creel, that kind of recently just spelled this out from the 11th Circuit. And basically, this is one where the plaintiff was a lieutenant in a jail in Florida, and her position was eliminated. She requested a transfer to a lieutenant position, but there were no positions available. So they offered her a job in a shift detention position. The shift detention deputies worked fixed 12-hour shifts. At that time, when they were having this discussion, the plaintiff at that time, for the first time, indicated she had a medical condition and needed to be miss work due to ongoing treatment, and again requested a lieutenant position. The lieutenant position would have allowed her to work a standard 8 hour a day, 5 day a week shift. Again, the employer was not able to accommodate because they didn't have any vacant positions. The doctor provided that the plaintiff could not do the position that was being offered by the employer. The employer ended up terminating her because she couldn't do the essential functions of the job that they were offering her. She filed suit claiming that the employer had not engaged in the interactive discussion, and they were not offering a reasonable accommodation that she recommended. The court ultimately said that the ADA does not require that the employer create a job if there wasn't already one there. And so I think this just puts into play, and I know there's some more court cases coming out, and obviously over time, we'll see more if there's consistency across the board, but the ADA does not require employers to create new jobs for employees. And then the last thing it's not intended to do is it's not intended just to become a leave law. I mean, we have leave laws both at the federal, state, local level. Some employers have their own company leave, but it's not, ADA is not necessarily going to apply in every situation where somebody's off of work. And we've seen situations now where I think some employers are maybe confused and trying to, or employees are confused about, casual 1 or 2 day absences for various reasons, that for the flu, pneumonia, things that we all have, probably in a year. Those clearly aren't covered by ADA, and they shouldn't be considered under that. So I think, again, as we've seen the Act, get passed, evolved, and now really back to its basics, we've also seen now a shift where I think there's still some confusion on exactly what should be covered under the ADA and what the ADA is not intended to do. So let's talk a little bit about the basics about what the responsibilities are for an employer. Obviously, compliance the employer is responsible for being compliant with the law, and so that's obviously very important. The law, as it's been amended, and I think this goes back to the original intent, is really in all honesty, it's an employee-friendly law and puts burdens on the employer. And while we all may not like that, the reality is that's what it is. And so it's incumbent upon us to be compliant with this process. The interactive process is a core component of this. It's clear that there wants to be dialogue. It can't be just the employer deciding on what's best from an accommodation perspective. There needs to be that discussion. But again, as I pointed out in the recent court case, it doesn't mean that if the employee offers up an accommodation that you always have to take that accommodation. It's just really to have a discussion and go from there. So your record keeping and tracking is clearly important from the employer's perspective. We're in a pretty litigious society today, so everything needs to be documented in order to make sure that you can have a record of what all happened. It needs to be consistent. Oftentimes in any one of these situations, you never know which one may end up becoming a lawsuit, so you need to make sure you have a mechanism and a process by which a tool by which you can do this. One thing we've seen recently is employers, and Shawn will talk a little bit about it, where employers are taking some of this off of the HR generalists and now putting it more into centralized groups or with centralized resources. So it's easier from a consistency standpoint to have a few people doing it as opposed to a lot of people doing it. You need to identify all potential accommodations, and I think that's one of the things. The amendments are clear and the intent is clear that they want employers to try to accommodate as many positions as possible. And so sometimes that means, thinking a little bit outside of the box or looking, as technology changes, there's obviously different ways that workstations or work processes can be adjusted based on technology that can help allow somebody to be accommodated. The same thing with work from home arrangements or flexibility of work schedule. So all those things need to be considered when we're identifying the potential accommodation. And ultimately, the employer is responsible ultimately for the decision on which accommodations can be made. And on the flip side, when they can't make accommodations, and they need to make sure they can be able to legitimately explain why or why not they were able to accommodate. So the burden, I wish there was something different I could tell employers, but it's not going to change. The burden is largely on the employer and to be able to evaluate this process and try their best to accommodate their employees. So from a compliance perspective, again, I talked about the burden of proof. Unfortunately, this would all be a lot easier to all of us if there was just a blanket rule, if there was a list of rules of compliance, if there were these 10 rules and here's what you need to do, and if we just had to follow them, that would make this a lot simpler, and we probably, instead of having 500 people on this call today, we probably have 5 or 10. Unfortunately, that's not the case, and so it's clear that each case needs to be evaluated on the specifics. You need to be able to do that consistently. And, in the reality of the situation, over time, we will probably be given better guidance based on court cases and, cases that get to the Supreme Court. And over time, there'll be better guidance. It's going to take a while, though, so in the near term, I don't think we're going to get to clear up some of this stuff. I mean, one of the hot items that continues to be out there is what is reasonable. And there's not a simple rule of reasonable means you need to do it for 6 months. In some cases, 6 months may be reasonable. And other times, 6 months may not be reasonable. 4 months may be reasonable. And so, there's not a simple way to do that, and there's not a simple for these jobs or these types of accommodations. It's this amount of time, because you have to take a look at all the varying aspects of each request, what the job is, the importance of it, your ability to accommodate it. So that's going to continue to be a barrier that we have in this situation. And if compliance, I don't need to tell anybody on the call about the cost of compliance. Obviously, the things listed here are important. Clearly, reputation of the company is one that we all protect for our employers, and that's important. Obviously, none of us want to have our company's name on a lawsuit that, from an ADA perspective, where we ended up having to pay out, and we're in the headlines of the major newspapers. Not only is there the monetary cost of it, but there's the overall brand. It can impact people's ability to recruit if they see the employer as someone who is not compliant with things such as the ADA. So compliance is a challenge. It's not easy, but it's also of utmost importance when we're talking about this situation. And so with that, I know there's obviously some challenges and barriers that employers face. And so with that, I'm going to turn it over to Shawn to talk about those.
Thanks, Darryl. So Darryl kind of talked a little bit about all of the compliance factors that are required by the law of the employer. So now we're going to talk a little bit about some of those challenges and some of the things that we've seen from our perspective employers put into place or starting to do to sort of address some of those challenges. So first and foremost, one of the challenges that we often see is really lack of expertise to understand an employee's true capacity, and then figuring out what the core essential job functions are and how to sort of marry those two up. And so in our world, we would use somebody like a vocational rehabilitation counselor, so somebody by background who understands functional capacity, what it means, and how different tasks can be modified to allow that person to still achieve the task. There's other clinical resources that can be brought in, anything from, kind of an RN level all the way up for more severe cases, all the way up the chain to treatment providers. So really what we're seeing is that for the most part, most employers who aren't in the healthcare space do not necessarily have vocational rehabilitation individuals or RNs or, MDs on staff. And so when they get requests for these types of accommodations or just realize that somebody is no longer able to perform the job functions as they are today, they really don't have anyone to go back and to really gather that expertise and be able to make recommendations on what those accommodations might be. So we're seeing a trend towards either hiring, so having us part of a dedicated team that's responsible for this, having some type of clinical expertise involved in the process, or obviously partnering with, whether it be your healthcare provider, a TPA provider, some other insurance provider that you're already using for clinical resources for other leave types. We're seeing employers really start to engage that expertise in the process to make sure that we're seeing the best possible outcome. Also, one of the challenges that we see employers facing is really just establishing and ensuring that a consistent process is followed across the organization. So obviously one of the goals is to make sure that every employee out there with some sort of medical condition is evaluated properly and goes through a full interactive discussion, understanding of what their current situation is, what their limitations are, and what their capacity is, and then entering into dialogue both with the employer, with the manager, supervisor, and or HR individuals, perhaps even the treatment provider, to really understand fully what is going on so that the appropriate actions can take place. Oftentimes, as Darryl said, the trend previously, before this sort of came into the limelight in terms of ADAAA, ADAAA, we were seeing employers have the responsibility of, 50 different people out in the field that had oversight for an HR function, or even the frontline supervisor manager, and to try to ensure that a consistent process is taking place is difficult to do when it's spread out to the masses that way. So we are starting to see a trend towards centralization of that. It's also important to keep that process simple. You don't want a process by which is so convoluted that, even the experts have a hard time following it. It's really about, it's it's not easy, but it's also not rocket science in terms of really it's about identifying what the capacity and what the needs are. What are potential accommodations that can maybe meet the employee's needs, engaging in those interactive discussions with the appropriate individuals involved, and then determining whether or not that accommodation can be met, and if so, making sure that that gets implemented properly. So again, they're unlike FEMLA, unlike some short-term disability regulations or workers' comp regulations. The one good thing about the law is that they haven't necessarily mandated certain communications that are required, certain rights and responsibilities that are required. So far, knock on wood, there isn't a lot of requirement by the government in terms of what that process has to be. It just needs to be that there is an actual evaluation that is done. And then obviously once that is done, then it's about the documentation. So, as we always say in the claims world, if it's not documented in the claim notes, it didn't happen. And that's very much sort of how the courts usually tend to look at the documentation in terms of an ADA event and what you can prove that was done or wasn't done. So the lack of ability to provide documentation of interactions that might very well have taken place really comes back to cause employers to be on the hook for things that maybe even were done in the right way. So there's also a lot of interest right now in different, whether they be formalized systems that are available in the marketplace to track all of those interactions. And really, a lot of those interactions are now able to be quote unquote transcribed so that they can be agreed upon by the employer, by the employee, that this truly is what took place and really can become part of the employee's personnel file. The other reason why that documentation is so important is because, people come and go every day into different jobs, and employers have gotten themselves into trouble when a supervisor or manager has agreed to something with an employee, and so that employee thinks they're fine and covered and has a reasonable accommodation that's been made. And then when that manager moves on and somebody new comes in, if there's no documentation of that, if that then is violated, that opens up the employer for risk in that way. So obviously the documentation is there to protect you as your employees move around within the organization or outside of the organization to make sure that that historical information is available. So next, we're curious whether or not you, as an employer, have currently any expert clinical resources that assist you with your ADA process. So again, this can be anybody from that has that true vocational background, or any type of a clinical RN, behavioral health specialist, MD that's involved in that. To help you determine sort of what are those reasonable accommodations and how can those job tasks be tweaked without really impacting at the end of the day what the core function of the job is. So we'll give you just a couple of seconds here to answer this. My guess is that most of you currently do not have, based on what we've seen from our client population and others that we talked to about this, our guess is that most of you probably are not fortunate enough to have a clinical resource involved in this. And if that is the case, as you're evaluating sort of your process and how you make that better, that is something, that we would encourage you to look into and determine how can you make sure that you're getting the right level of expertise involved, because it honestly will help you at an employer perspective in terms of really coming up with, and we're going to talk about, some more creative solutions to accommodations towards the end of this, but it'll really help make it easier for you guys to identify really what are some of those reasonable accommodations that might be able to be met. All right, do we have the results of those polls or? All right. Well, while we're compiling the results of that, I'll go ahead and talk. Oh, there we go. So, as expected, actually, it's a little bit higher. Almost 30% of you, 29% of you, do have somebody involved in the process, which I think is great. Probably a lot of those might be from the healthcare industry, but almost 70% do not. And so, oftentimes, what's happening there are we're seeing a lot more of leave as an accommodation in those situations where there's no expertise, because if somebody doesn't really know how to modify the job to let them to allow them to continue working, oftentimes we're seeing a trend towards we'll just give them some leave and let them go out, and then hopefully they can come back, in a quote unquote reasonable amount of time and now be able to do their job. But honestly, most of the time, leave as an accommodation is not necessarily getting to the root cause of why they need the accommodation and changing that job to allow them to do it. So that's not surprising, those numbers, although, like I said, the 30% is probably a little bit higher than what maybe we've seen across our clients. So let's move on to common compliance gaps and what can be done. So Darryl kind of alluded to earlier, nobody, I don't care how good your organization is at these things, nobody can stop a lawsuit from being filed against you. So obviously the goal of having, if in fact that does happen and we all have them occur, once that happens, obviously the goal is to make sure that you have a defensible case and that you can prove that in good faith you entered into an interactive dialogue with the employee and then an evaluation was done of their situation, of their particular job, to determine whether or not a reasonable accommodation could allow them to continue working. And so training, obviously, we see a huge gap in training. And sometimes, especially as we've seen employers start to do a more centralized group that is going to administer their ADA process, they're now they're leaving the frontline supervisor, manager, HR individuals out of any training because they're not the quote-unquote experts, so they don't necessarily need to know. Well, that's a complete gap in the process because oftentimes it's that supervisor, HR individual who sees firsthand a potential need for an accommodation, or they're the first one to get notice of it. And so they really need to be trained not to be the experts in understanding the law and understanding how to accommodate, but they do need to be trained in understanding what are the appropriate next steps, how do they engage the appropriate resources within the organization, and really train to recognize when there could be a potential need for that accommodation. And then obviously when whoever is ultimately responsible for it, whether that's a centralized team of experts, whether that is still sort of that HR generalist level, they obviously need to be trained both to be the experts, both from a recognition of the need for accommodation and also what appropriate interactions need to take place during the process. So, for example, oftentimes employees are sometimes hesitant to come forward with these things because these are usually personal situations that they're dealing with, a personal health. It's not like it happened at work and so everybody knows about it. It's usually a very private matter. And they're oftentimes concerned about having their employer know their full health history from a personal standpoint. And so what we would encourage is to make sure that the only medical facts that are really being discussed during these discussions are what the limitations are and what the functional capacity of the employee is. Really, the underlying condition is not important. It doesn't, that doesn't need to be a large part of the discussions. It really comes down to what that employee's abilities are to do and not able to do. And so it's really training to make sure then that your employees are not feeling like that their confidentiality is being violated, and also that keeps you out of a touchy situation in terms of HIPAA and compliance from a confidentiality standpoint. Communication. We see all the time, these are difficult conversations sometimes to be had. They're uncomfortable. They aren't necessarily what, you're trained to do as a supervisor, manager, HR individual. But not having the regular communication is oftentimes what starts the chain of negative impact. So it's key that communication is there, both between the employee, employer, supervisor. This is where you want to make sure that you're engaging. If you have employment counsel on staff, you want to make sure that all parties are privy to the same communication, so that at the end of the day, regardless of what the decision is, everybody is communicated with and clear on what the outcome of that accommodation request is. We talked a little bit about documentation. It's important that every step within that process is documented. Who was involved in the conversation? Making sure that it's documented accurately. That's why oftentimes it's good to be able to produce sort of a transcript or a summary of the discussion, what was discussed, what the outcomes were, and even going as far as to ask the employee to sign that and the supervisor to sign that, so that everybody's aware of really what were the outcomes of those discussions. And then having that as easily a complete sort of file of the event of what happened, so that if by chance you ever do become involved in a lawsuit over it, you can easily produce the entire A to Z history of what happened within that event. And then consistency. Obviously, everybody is eligible under the ADAAA law to be evaluated. However, oftentimes consistency gets following a consistent process can oftentimes be confused with, well, then I need to do exactly the same thing for employee A that I did for employee B. And that's absolutely not the case. And Darryl said earlier, every single case has to be evaluated in terms of what truly is their core job. I know at Sedgwick, I share the same job title as 6 other people at Sedgwick, and I can tell you that my core job function is really not the same as those other 5 people. Oftentimes what your title is or what you're actually, thought to be doing every day might be different than reality. And so it's really looking at their particular job and understanding what it takes every day to do the job and to meet the expectations of that job. Because again, it's not about removing expectation. It's not about changing the job and now they don't have to do as much as their colleagues sitting next to them. It's about allowing an accommodation that allows them to continue achieving what the expectation of that job is. So again, you can have 2 individuals with the exact same medical condition that, depending on what their true functional job capacity or job duties are, may or may not end up with a reasonable accommodation that can allow them to continue working. So the consistency is really in the evaluation process, not necessarily in the outcome. The other big topic as of late has been sort of identification of need for an accommodation. So, I think back in when the law was first enacted, it was sort of thought upon as, well, if an employee comes to me and asks me for an accommodation, then I'll evaluate that. But that certainly has been frowned upon by the EEOC, and this is where you really oftentimes get into sort of that intersection, if you will, with workers' comp, other disability plans that might be in play, leaves of absence like FMLA, et cetera. And so really it's up to the employer, if they're aware of a situation like one of these facts that they've already been off of work for some amount of time due to a medical condition, workers' comp, disability, and a leave of absence for their own serious health condition, obviously have an underlying medical component to them. And so if there's an awareness of that, it's imperative that the employer is engaging with them to ensure that at the end of that other type of benefit, that if it's appropriate for an accommodation, evaluation, discussion, interaction to take place, that that's being done. And for a while, the trend was sort of, well, we'll put some language in an STD exhaustion letter or in a leave of absence exhaustion letter or in a return to work, workers' comp letter. We'll put some language in there that says, hey, if you still think you need an accommodation, let us know. And now what we're seeing is what we're encouraging is that really that dialogue takes place throughout the life of the workers' comp, the disability, or the leave claim, so that it's not sort of at the end of this claim, then we'll talk about, ADA, but really to sort of incorporate the ADA process along the way and to be having those discussions. We know that oftentimes, especially physical conditions, I fell and hurt my back, I fell and broke my leg, that oftentimes those can result in, short-term short-term restrictions and limitations that most employers are comfortable with accommodating. But oftentimes, especially in the short-term disability and leave of absence world, a lot of those conditions are permanent chronic conditions that employee is dealing with. And if that's the case and an accommodation is needed to help them perform those job functions, we need to be proactive in helping to identify that and engaging in that process. The other thing is, if you have an employee that's struggling with their job, again, this is, a little word of caution here. We're not saying that, if they're struggling to do their job because they really just aren't capable or aren't putting forth the effort, so i.e. performance issues, that is, not at all what ADA is meant to sort of help resolve. But if they aren't able to do their job because of a condition that they have that is limiting some functionality, and we observe that as employers, it is our duty to, again, communicate with them, ask them why they're struggling, talk to them, have those difficult discussions to determine whether or not it's appropriate to move forward with further evaluation and interaction through the ADA process. So again, it doesn't have to be the employee coming to you requesting a specific accommodation. It really is up to you to use the information that you have or the observations of your supervisors, managers, HR individuals to really be aware that, this could potentially be something under ADA that we really need to investigate and determine whether it's truly performance issue or whether it's truly they are struggling because of a condition that maybe we can help bring some relief to and allow them to continue working. So next polling question we have for you is just kind of curious. Do you have a centralized team that administers ADA in your organization, or is this still sort of, so yes or no? And if it's no, we're guessing that means that your frontline supervisors, managers, and or HR individuals are involved in that process. And again, especially depending on the structure of your organization, depending on the different levels of resources that you have within the organization, either way can work. We think it's harder to spread it out amongst the frontline supervisors, managers, just because they get so busy every day making sure that the work gets done. So whether you're a manufacturer, making sure whatever the quota of getting made that day is done, or if you're a service industry, making sure that the phone gets answered and appropriate services given. So, and they get caught up in HR issues and, payroll issues and all kinds of stuff that oftentimes dealing with somebody who needs an accommodation is not necessarily going to be first and foremost their priority. And obviously it does need to be somebody's priority. So that's why we're seeing a trend in the industry or across employers sort of move towards having a centralized. It also then allows easier ability to see whether or not that consistent process is being followed on a employee by employee basis. So here we have the results. So 46%, so it's almost 50-50, which is definitely, I think, had we taken this poll, even 2 or 3 years ago, I think that number would have been significantly lower. But obviously, you guys, too, are sort of following that trend to put it in a centralized, more expert team. And then lastly, we want to encourage you guys to think creatively about accommodations. So what we see oftentimes, and again, I think this is lack of knowledge, lack of expertise that sometimes leads to this, but the quote-unquote easy accommodation, now that it's allowed, is put them out on leave. And again, as I said earlier, that's really not getting at the root cause of the issue. And so that's really never going to solve the issue. And it's also burdensome to your staff, to your supervisors, managers. We all know dealing with an employee who is off of work and trying to cover that work, because oftentimes you're not going to get an extra resource to cover that work. And so that really becomes a big burden from a productivity standpoint on the organization as a whole. And so really, honestly, that leave as an accommodation should sort of be used as a last resort. Like, yeah, there is no other way to do this, and we think that truly it's a situation, it's a exacerbation, it's a flare-up, it's a something that if we give a, reasonable, fairly short amount of time, that employee will be able to come back and do their job. And that's really what it's meant for. Or it's meant for the employee who's been out on leave for 12 weeks, and because FEMLA says you get 12 weeks and they need one more week, that we're not terminating them, that we're allowing them that one extra week to do their final healing or therapy or whatever, and then come back to work. So it's more the exception than the rule, and what we're seeing is oftentimes an employer really using that as sort of just the standard go-to first response. Flexible schedules. Oftentimes, if you can just tweak that schedule to allow a little bit starter late time a little bit later start time or a little bit earlier end time, that, based on certain conditions, that might be all that employee needs in order to continue being a high-performing employee for you. Telecommuting. I know this is a hot topic with a lot of employers. Do we really want to do this? Do we not? It's definitely not the right solution for every job, but it can be a viable solution to allow an employee to continue working in their own personal home environment. And again, it depends on what type of job they're doing. If their job is to be in an office collaborating and working as in more of a group environment, then that's going to probably be more difficult to do at home. Although with technology and everything else that we have today, the options under telecommuting are much greater than they would have been 5 years ago. So it's definitely something that needs to be looked at in your organization. Different locations just within the office, not necessarily a whole different office, but a different location. So take the example of, IBS. If that individual is smack in the middle of, 100 cubes, and every time that they need to use the restroom, they're now having to, basically run through 40 of their colleagues to get there, that's going to be uncomfortable. That's not going to probably work for them. Whereas if you move them to a cube perhaps right outside of a restroom facility, that might be all they need in order to continue the functions of their job. And then obviously, alternative jobs. So if really at the end of the day there's not an accommodation that can be made that allows that employee to continue in that job, are there other, jobs within the organization that they could transfer into? And one of the things, that you would want to consider is there a formal job search program to help employees find a different position within your organization? Obviously, if you went through all these steps and you even went as far as to try to see if there are other jobs by which could be modified or which they were qualified for within your organization, obviously those are all going to be favorable in a court size in terms of good faith in trying to do all that you could do in order to help that employee remain employed. So with that, I think that we're going to open it up for questions and answers.
Yes, we will, and I'll just encourage you, if you haven't yet typed in your questions, you can use the Q&A panel in your WebEx screen. We are getting a lot of questions in, so I would imagine we're not going to be able to answer everything, and we may not be able to get into the specifics of detailed situations, but I'm going to do my best to work through these with Shawn and Darryl, and then we'll follow up with additional information beyond the webinar. But let's get started. I have a question from Elizabeth, and she's asking about union employees. So union employees pose an additional challenge since they cannot always perform other job functions outside of their job description. Do you have any advice related to union employees?
Well, and I'm assuming that's being asked because of their union contracts and what, you know, they're capable of doing. So again, the employee is responsible for engaging in this interactive process along with the employer. And so if the employee is refusing to take another position within the organization, and if their job that they're in within that union is unable to be modified, then that could be a situation where it's not, you know, where there is no reasonable accommodation. So again, the employee has to be engaged in this, and sometimes they will be the ultimate ones who make the decision whether or not they're going to accept, you know, a different job or modifications to their job. And if their refusal to do so could then become an employment action rather than an ADA action.
Okay, we have a question from Kathy. She asks, shouldn't the employer be made aware of a disability before hiring the employee unless the disability happened while they were an employee already?
Well, I think I'll take that one. I mean, you can't ask, prior to making a job offer, you can't ask a bunch of questions like, do you have a heart condition or any of this other stuff. So in that situation, the employer wouldn't always know if an employee, a potential employee, has a need for an accommodation. So the simplest answer to that is the employer's not always going to know. Now there are some times where maybe the disability is obvious during the interview process that the person has it, and so there could be a question asked there, but I would say a lot of times you would not know. And prior to making a job offer, there is not a requirement that the employer ask for an accommodation prior to any kind of job offer.
So then a similar, I guess, an appropriate follow-up question comes from Jackie. When are you allowed then to start the discussion about accommodations?
Well, again, I think it goes back to Shawn's point. And once you're aware as the employer that the person has a disability where there is a need for an accommodation, then the discussion should start at that point in time.
Okay, here's another similarly related, I think, question. If someone comes to us in HR and tells us about a disability they have, for example, they know they're autistic or have ADHD, but they do not request an accommodation, they just want to, quote unquote, let us know, how would that be handled? Would they be obligated to give an accommodation at that point?
Well, I think it depends whether or not there's observation of struggling to perform the job task. So obviously, I mean, just because you know somebody has a condition, that doesn't necessarily automatically make them needing of an accommodation. So just knowledge of a condition isn't necessarily means to start the interactive discussion per se. However, if there is indication that the employee is struggling to perform the job task and we have knowledge that they have ADHD or any other type of cognitive type of situation, we would absolutely want to make sure that you went through the process to determine, is that the underlying cause of the inability to complete the job task? Or again, separating out, is it related to a medical condition and functional capacity there, or is it a performance issue? A performance issue. So just being aware of something doesn't necessarily mean that any accommodation is needed. So it's really, if they tell you that, hey, I have ADHD and, oh, by the way, I'm struggling to, do this part of my job, then yes, you would be obligated. If they say, hey, I just want to let you know I got diagnosed with this, until there is a reason to believe that that could be impacting their job, then it wouldn't necessarily be required to go through, a formal ADA process.
We have another question related to performance issues from Andrea. So she asks, in a situation where an employee has performance issues, yet after addressed, the employee stated their supervisor stresses them out, causing depression, anxiety, and they're now on medication and unable to perform well. So if the supervisor is not doing anything illegal, do you initiate ADA, or do you deal with the performance issues only?
So again, each situation has to be looked at. If the employee comes in, and most likely that employee is not going to come in and give us all of that, that now I'm taking medication and that, this, that, and the other. So depending on how the employee brought that to you, if they came to you and said, I'm struggling to do my job because I have, what would be considered a behavioral health condition, and the medication that I'm taking makes it unable for me to focus, unable for me to do a certain part of my task, then yes, we would need to look at that to see if there are things that could be changed within that job. However, if that wasn't necessarily the case, if they just said, I'm stressed out and they're not performing their job, then that isn't necessarily reason to have to engage from an ADA perspective. It really depends on the observations that are made in that particular situation and really what we know, because oftentimes the employee is not going to share that level of personal detail unless, pressed or unless, something further comes of that.
Yeah, and I would say, Shawn, in a real-life example at Sedgwick, we had a situation where an employee had a similar situation from a stress, was saying that's the reason why they were not able to actually, maintain their performance standards of handling claims, for instance. In the case of they were claiming, stress, anxiety, all that due to the supervisor, we were able to do an accommodation by allow that person to move to a different supervisor with a different skill, different approach. And so when we got that out of the picture, then we were able to. It got to a point where it was clear it was no longer about a stress or anxiety, but the issue became that they couldn't do the job. So I think you really. I'm not saying that's the way it's always going to parse out, but you do need to look at that, and if there is a ability, if they're claiming they're on medication, missing work, and using that as you need to, for your own benefit, I think need to try to figure it out, try to make an accommodation. If you can maybe, if it's about a supervisor, can you move them to a different supervisor, and then maybe if that helps resolve the issue, then you're back. Now you've isolated that it's back to a performance issue.
Here we have a question that is IT related. So how do you determine how much is too much information to track? And I think that ties into systems.
Yeah, to track, we personally would say that there isn't too much detail. The more detail that you have regarding each step of that process, each discussion that was had, the better. Now, what becomes key of that is that you have well-trained individuals that are sort of overseeing that process so that they know, much to my point of, personal health history and what information they should be asking about and what they shouldn't be asking about. It's obviously key to make sure that those experts are truly experts in those things. But honestly, the more detail you have to quote unquote prove what happened during that evaluation process or during that interactive process, the better the better chance that you have of defending that if it were to result in some sort of a legal action. I mean, just real quick from a Sedgwick example, I mean, the things that we document are specific questions that are asked in those and the answers given. We document who all is engaged in each of those. We track, the date and time when all of those interactions took place. We track the specific requests and the medical information received from the doctor. Everything is date and time stamped. Everything is to that level of detail, because that's really the only thing that you have to show from an objective standpoint of what has taken place.
I think we have time for maybe just one more question, and I'm going to ask this one. So it comes from Carol. She's saying that in her situation, they have employees asking for retroactive ADA protection when they are brought into discipline meetings and their time off after FMLA exhaustion is being discussed. So how can that be handled? How far back should be protected?
Well, it depends on what the situation is. So again, we're seeing a bit of a trend with employers that, it depends what they're alleging, I guess, or what the condition is. So again, ADA was not meant to cover an absence or an attendance policy. It wasn't meant to protect the employee for things like laryngitis and pneumonia and the common cold and those types of things that just we all deal with every year and need a day or two off here or there. That's not at all what the ADA was meant for. So again, without knowing the specifics of why were they off of work originally, and did they truly have a condition that should have been considered under this? And that's why enacting that interactive discussion early in the leave process or in the disability process usually proves more fruitful, so that then at the end of that or 6 months later or whatever, they can't come back and say, well, really I needed an accommodation and I just never asked for it. So there's no hard and fast rule that says they can't come back a year later and claim that. But really it has to be looked at on the merits of what all the facts surrounding that case were. And I know we're over, so.
Right. There are still a lot of questions that have come in that we're not going to be able to address, but I would like to encourage everyone. You can see here on this slide, we've got additional ADA, ADAAA materials that you can take a look at on the Sedgwick website, on our blog, and in our magazine called The Edge, which has a couple of specific, very relevant articles from Shawn and Darryl included in the last couple of issues. We will additionally be following up with not just a recording of this presentation that includes the slides, but also we will do a follow-up on our blog that addresses some of these unanswered questions and some of the frequently asked questions we are seeing. So keep an eye out for additional information from us at Sedgwick, and thank you so much for joining us today. Thanks, Shawn. Thanks, Darryl, and thank you, Sharon, and the others at Human Resource Executive. Thank you, everyone. Have a great afternoon.